My name is Fabia. I'm from the Federal University of São Paulo, and I'm going to be with the presenters and discussants on our panel 3 on India. I would like to introduce our main presenter, Prabhakar Singh from the National University of Singapore, and our discussants, Nick Robinson from Harvard, Balakrishnan Rajagopal from MIT, Arun Kumar Ter Yuvan Gadam from National University of Singapore. So the floor is yours. You may start.
Thank you. Thank you for all the presentations in the morning. I thought it was a little overwhelming given we were talking about all kinds of theories to explain law and development. In my paper, which I did circulate, I tried to be as expansive as possible in terms of including what has been happening in India before independence and since independence. I think, so my paper is largely descriptive, but it does answer the questions that have been raised generally in the panels and in the discussions among scholars about what it means to do law and development scholarship in India. I would begin by simply pointing out that this whole law and development, mapping law and development scholarship in BRIC countries, so the whole idea of BRIC is economic, right? So that's how we start. So we start from this idea of, how to bring together all these countries that seem to have similar growth path, similar GDP, etc., and we bring them together. So the idea of BRIC itself is economic. That's how we start. And then we go to the question of whether, so development is already there. These countries are worth studying because there is some sort of development. And then we start to look at if law has played any role in development in these countries. We've had a very interesting presentation about China. And I think India is, in terms of its approach to development, has been as different as possible from China. This has to do with history. Our history is a little different from Chinese history. It starts with colonization, the modern history of India, of course. And that essentially, what it does is that it does give us a rule of law vocabulary. So we start with, so in the early period of colonization, it did create pockets of cosmopolitan cultures in different parts of the country. And it created a new brand of scholars, thinkers who sort of realized that Indian system had a lot of issues, for example, sati, caste system, all these regressive systems, and naturally, their first attack on this system was actually orchestrated by their own, the interaction of the East and the West in India. This is true. So the first wave of modernization, actually, in that sense, legal modernization comes to India with Indian experience of colonialism. So we have a whole set of laws promulgated to ban sati, which is really like in 18 something. And thereon, so we moved with a law, rule of vocabulary. It's also worth noting that the freedom, the people, chief leaders of the freedom struggle were all lawyers. And Gandhi, for example, himself was a lawyer. And then we had, when we became free in 1947, the first prime minister was also a lawyer. And naturally for him, he had, so rule of law did have some appeal to the Indian leadership since the beginning. Even though India did try to play a game of, being non-aligned, so non-aligned movement, and India's Prime Minister Nehru was trying to sort of come up with the alternative world order where it's not, India is either, is aligned with none of the powers, either Russia or USSR or US. And it's in that environment that India begins to experience its development. The first round of development was, since 1947 and the constitution came in 1950, which is just 3 years after the Indian independence. So the constitution and the court started functioning very early. Can I just use this? Hello? So, the begin, just like in China, we had 5-year plans through which we wanted to modernize the country. That's how we all started. And in the beginning, it's worth noting that Nehru, as the Prime Minister, took special interest in inviting foreign scholars to study the country and offer solutions. So this is a very clear-cut orientation for internationalism. And in the first phase of the birth of the modern India, it was quite open to people, particularly American scholars, who would come down on the invitation of the Prime Ministers, have a whole host of privileges given to ensure that they stay in the country and read the system, read the village system or urban system, and offer solutions. Ford Foundation, for example, came to India very early, and the then government actually gave full support to the functioning of Ford Foundation. It was not just so the engagement of Ford Foundation was very much entrenched by the positive view of government in terms of borrowing ideas from countries that had already developed. In many ways, like I've said before, it had to do with the internationalist vision of the Prime Minister then. He realized that having had education outside and having had that international experience, he realized that India had to learn from experiences outside, and the experiment. But the point to be noted is that the first phase of the Indian, since the Indian independence, was essentially about industrial development. If you look at the funding towards education, it appears that it was the focus was less on education in that sense and more on industrialization. So this marked a clear shift from how Gandhi had seen it before independence. So Gandhi would always talk about village Swaraj, which means village democracy, village being the system, center of India's system, and that the things must start from the village. Whereas when we became free and Nehru became the Prime Minister, his idea was more industrial. So it's a clear-cut change in terms of how the government was thinking. In my paper, I detail actually about how Ford Foundation and other such organizations came to India, and they would invest in different universities. They would try to create departments. They would basically fund, try to create centers, and by funding universities to basically discuss all kinds of issues. So, for example, in the first phase, you had the Indian Law Institute. So that's a discourse about India. So when we started in the beginning, it was not that law was left out. So we had institutes on public administration, but we also had fundings in Indian Law Institute. So my point is, so we have had this law talk since in the morning without actually mentioning the word court. So, I think it's quite distinctive because all this law talk, whether there's a rule of law or whether this is a good frame to sort of discuss development, I think in India cannot be thought without actually thinking of court. Because Indian court has been very distinctive in terms of enforcing all these, enforcing policies or turning them into law, even to an extent. So, the first period, of course, like I said, 10 to 15 years was all about the executive being very active, importing policies, importing scholars to study the country, offer a whole set of reform report and sort of say what to do. But thereafter, there was, so since Indians in general had they thought that engagement with law is very important, a very early debates started about the whole idea of transplantation, which is traditional law versus modern law. And it's interesting to note that when the British came to India, they didn't touch the personal laws. So we had all kinds of modernization, all kinds of laws. So criminal law, which is a secular law, but they didn't touch the personal laws, which is family law, laws about marriage and inheritance. Precisely because India has a huge Hindu population and a huge Muslim population and all kinds of other religions. So they thought it was best not to touch that and basically focus more on commercial and criminal law. So for a very long time, all laws were codified, but the family law, the Hindu Marriage Act, for example, or other family laws were only codified in 1955. So India became free in 1947, and then the laws were codified in 1955. And this led to controversy in terms of what India or what Indians thought was the law. So a very good example is that when we had the Hindu Marriage Act, the Hindu marriage is seen not as a contract, and it was seen as a sacrament, because Hindus believe that we marry for 7 lives. Well, in that sense, when Nehru, for example, wanted to import basically the idea of divorce, so divorce should become part of Hindu Marriage Act to ensure that women who do not want to sort of be with the person, they should have basically the idea of freedom. So they should have this option of terminating a marriage if it's not working. It's a very British concept, then at least. And it met strong opposition from the president. So the Prime Minister wanted the divorce to be included as a ground to terminate marriages in the Hindu Marriage Act. The president wouldn't want it. And so you can see this difference between approaches. The president was more conventional, while Nehru was very internationalist, and he thought it's an important part. However, he put his foot down, and then finally it was included. And that led to a discourse among scholars about the nature of Hindu marriage and how to sort of deal, or whether India had a sense of law which it enforced through Hindu law, or not. And some of the leading scholars like Duncan Derrett, they talked about it's the sanctity of, or Hindus or Indians already having some kind of a law which was altered by colonial experiences. So in the sense that we imported modernity by enacting a bill, enacting a law, Hindu Marriage Act, where we included divorce as well as a provision. And so there was this discourse about, well, we had our own laws, dharma shastras, and we are basically deviating from that law, becoming more Western. And but that was in the early period. And it's very surprising that some of the Western scholars also sort of tried to say that, yes, India had its own law, and the law of the marriage was seen differently. And yet it was a legal way of thinking. But then we had progressive scholars, even from India, sort of rejecting the position that if you have this kind of a law, naturally you're not going to emancipate. And you can see a connection, because as soon as, in the 1830s, when there were scholars who championed for banning sati as a practice, and similarly we had Indians post-independence saying, well, you must not eulogize these Hindu laws which do not sort of give enough freedom to women, and including divorce is perhaps right. So I think that's how this whole, so the intervention, the academic intellectual intervention of Western lawyers, mostly Americans, in India about law began with these questions of whether Indian laws were good, or whether such transplantations are good or bad for the country. So I detail the scholars, who for a long time talked on those lines. So in terms of transplantation, which was a point raised, whether that, because we are largely, as was instructed in the last session, that we have to talk about the role of law and development scholarship, how it sort of came about, and what was the development, what was the issues taken up by them, and how since the independence we have generated the scholarship, what were the issues raised, and what were the answers given to that. So the first set of, as I mentioned, discourses in India was about this Hindu law, or how the old Dharma Shastra, which is the old system of Hindu laws, interact with new system, and which should prevail and how it should prevail. It's very interesting because the British understood that it was very sensitive, and they didn't touch this issue. But as soon as we became independent, I guess, even with the post-colonial mandate, enlightened prime minister, or liberal prime minister, really thought that it's best to include this modernity within the Indian system. That's how you sort of, so even if you have a post-colonial political mandate, it doesn't mean that you sort of unlearn everything that you have, everything that you learned from the British or the colonizers. And so that is about the first set of discourses. Then there's a discourse of how, as the question was raised, in terms of how these laws include policies. So in the Indian Constitution, there's a specific mention of policy. So we have set of enforceable law, and then, at least in the beginning, early period, and there was something called directive principles of state policy. So the Constitution, in details, lists all those policies that it thinks one must take into account to adjudicate. And well, it took a while before the court actually started using, digging into the directive principles of state policy and then using them to pronounce judgments. But once it started doing it, I think, changed the nature of how Indian courts have shaped the rule of law in the country, if I may say so. Because the rule of law discourse in India has always been through the courts. So through a series of cases, the Supreme Court would talk about property rights, abolition of zamindari, which is landlordism, because the idea essentially was socialist, so ensure that the land is evenly distributed. So it would begin to talk about all these issues, and the government from time to time would come back to sort of say to the court that this is perhaps, getting into their domain, right? And much of the law developed in the country by this interaction between the judiciary and the executive. I think this is something which is special about India in that sense, that the court, the judges and the executive would sort of try to rein each other, and essentially that led to, and as time progressed, the court would get into all kinds of issues. So the court, for example, invented prisoners' rights. So all sorts of human rights would be actually imported by the court based on the understanding of number one, directive principles of state policy, and it imported all kinds of human rights through Article 51, which talks about India being, it gives which asks the state to follow international law. So a combination of these policy prescriptions in the Constitution and the ability of the Supreme Court to import international law to conventions to which India might not even be a party, but yet it becomes some sort of a customary international law. You see that the Supreme Court becomes very active, and it starts fishing all these rights from the body of international law and directly sort of does a kind of consistent interpretation. So it says where there's a law, international law, and a lot of countries are talking about it, and we have some problem here of human rights, prisoners' rights. We must look at those things happening there, and it's very simple to see. And Article 51 says that there's a mandate, so we must do a consistent interpretation. And my understanding is that that allowed the Supreme Court to go active in a good way, because it was increasingly handling issues that the government wouldn't legislate on. There was a phase also in the 1970s when there was a political upheaval and the emergency was enforced in the country. When the court became a little domesticated by the executive, but then to atone itself after the emergency, you see that the court becomes even more active to show that we are not really bound by the executive and we are free and there's a separation of power. So you see a change in how the court behaves before emergency of 1975 and after emergency of 1975. In my draft, I basically detail the issues on which the court went on. So how all these all these rights were discovered by the court, and they start from environmental right to right to food, right to education, prisoners' rights. So whole host of rights that the court, environment, sustainability, tribal rights, for example. So it was essentially, all of this was done and justified through the idea of rule of law. So, but it doesn't, this is not to say that the court would always disagree from the state. It would disagree in the sense of, importing human rights and making, discovering rights for the subaltern, as if I may say so. But it also, in a way, was aware of how the international system, so it has to ensure that it has some sort of a minimum policy space in terms of borrowing international law. So while it was borrowing international law, it allowed it to develop the jurisprudence on human rights within the rubric of rule of law, but it was also aware of the effect, the constraining effect that international law, borrowing international law, might have on the state sovereignty. And then we see that the court, for example, sort of plays that game, or it tries to strike that balance, and increasingly, while we can say generally that the court was very active, but then if you go to different departments of law, so if you look at economic laws, or if you look like human rights law, we see different degree of import and activity done by the court. So having charted that history in general, we have come, so in 2013, for example, the court now is very much aware of the fact that India should also have its own minimum policy space, given that India is a member of, it has signatory to so many international conventions, WTO, for example, and it has issues before it to sort of balance India's obligation under TRIPS, which is part of the WTO agreements, and the fact that India is actually a place which can produce very cheap drugs, for example, for AIDS, for patients not just in India, but around the world. And this is what is said in Novartis judgment of April 1st, 2013, that the Indian court cannot only cannot only give a judgment based on what based on whether it will affect India alone, but it has to look at what the judgment, how the judgment is going to impact the subalterns of the world, which depend on India, for example, for getting cheap drugs, etc. So you see that my point, I'm trying to sort of overstate the point that in India, all this discourse has been through the courts, and it cannot be. I mean, this experience is starkly different from how the Chinese have looked at court and how they place law, the rule of the idea of law within their idea of development. I would conclude by saying that, again, this whole idea of BRICS, the clubbing of countries under the name of BRICS, is an economic clubbing, because we are looking at growth indicators and economic performances, and that's how we decided to sort of read these countries. But these countries, I mean, China and India in particular, have had very different experiences and understanding of law. Indian understanding of law has been significantly shaped by its own colonial experiences, and which has mostly produced, I think, positive, apart from these sentiments about sort of losing your own law and losing your culture, I think it has produced a very progressive set of rights for people in the country. And now the court had taken it to a next level, I think, when they say that you don't only think about Indians, but you also think about people affected by India's capacity to produce cheap drugs, you know. So therefore, the Indian court has to think also about, it actually names countries in that judgment by saying that we have to think of patients in every part of the world which will be affected by more, that's about it. Thank you.
Yeah. You have about 10 minutes.
Yeah, so we use that in, I think, question answers. Yeah.
Okay, so Nick, please. Yeah,
thank you. And thanks, Prabhakar. I really enjoyed reading this paper. I know, coming to this conference even, I think this is a good example that, that it's difficult to know what the field even is of law and development. And so when you're asked to map something like law and development in India or law and development in China, as everyone here in the first session in the morning was debating what exactly is law and development, it's in some ways almost an unfair task at one level to then try to lay it on your shoulders. And I thought you did a very good job of pulling out many of the relevant issues that I think this audience would be interested in. It reminded me a little bit of, before I was a fellow at Harvard, I taught in Pakistan for a while. I tried teaching law and development. And I remember teaching that class, and it was the only time I ever taught a straight-up law and development course. And you get some of the theoretical literature that we've been discussing here. And then, one of the things I thought would be relevant, especially for a Pakistani audience, is, case examples from other countries which are at a similar level of development. So there were a lot of India case examples in the course, and there was also, a talk about the Ministerial Publico in Brazil, or things that might seem relevant. But it also struck me at the end of the day that this was first of all, it was very hard to find these case examples. There aren't that many that are produced that are, highly in every area that I was looking in. And second, it was quite subjective of why am I putting these case examples in the course instead of another set of case examples in the course. And so I thought, it was kind of misleading advertising even when I was saying I was teaching this law and development course, that, it was just this one section. So the next time I tried teaching anything like this, I taught it in India, and it was implementation of social welfare programs in India, because I felt like that was a little more I could hold on to. And I covered a lot of the same territory at the same time. But I think in these mappings, I think there's a subjective element to it as well, and what goes in, what does not go in. So I just want to touch on one or two points here. I know it's the end of the day, and I don't want to talk for too long, but I wanted to follow up a little bit on a point that Raj had made earlier and some other people had made earlier about this north-south, central, peripheral, developing, developed. Another way of putting this, which is different, but you also hear in the debate, is foreigner, indigenous, transplant, indigenous, insider, outsider. This often has to do in the historical context of World Bank initiatives or ABA rule of law initiatives. Who's the outsider coming in? Who's the insider? And I do think India is an interesting example on a number of levels. So one is this very long history, the kind of a classic rule of law history in some ways that you would think about it if you have a very independent judiciary, particularly at the top in the high courts and the Supreme Court, that seems to conform with some elements and goes beyond those elements even. It becomes even more strong than in much of the West. And you also, I was thinking about who are the major development economists in India today. Who comes to mind when I think about who's in the newspaper, who's pushing debate, who's pushing policy? And I thought of kind of 4 leading development economists today in India. You could make 5 or 6. I don't want to leave people out. Amartya Sen, right? Harvard, Cambridge. He's in the paper. He has recommendations. Jagdish Bhagwati, Columbia. Rajan, who was at U Chicago, is now the head of the Reserve Bank of India. And Jean Drèze, who's a Belgian by nationality, now is an Indian citizen. He's actually the only one who's lived in India for the last 20 or so odd years, and is still based there, and is an Indian citizen. I think all the rest are Indian citizens except for Bhagwati. But these are people who each have different competing visions of development in India. They have very highly articulated, sophisticated visions of development in India. And they're both insider, outsider. It's unclear what direction anything is going in this debate. Who are their influences? Amartya Sen is, informing the West about India and is the foremost expert in that. But some people in India would accuse him of importing Western values into India. So it gets complicated in that way. And I think it's worth excavating that. On the law side, as you point out, there's this strong, proud tradition of constitutionalism, of strong independent courts. We don't have individuals kind of at the stature of Amartya Sen within kind of in the legal community, but there's certainly people like Upendra Bakshi and others who have articulated in the legal academic community a vision about the law in India, which is reminiscent to many things out of the liberal tradition of the West, but is with these Indian characteristics and things like public interest litigation and later things like the basic structure doctrine. And the judiciary itself, I have found in India, although very perhaps because it is so independent, is very wary of foreign intervention. So I think if you went to some countries, so one contrast to China would be in India is that you have this very independent judiciary. Judiciary is very central in politics. A contrast to, I think, other countries in South Asia, for example, would be the World Bank and the Asian Development Bank has had much more success trying to do judicial reforms. In Pakistan, there was a $200 million Asian Development Bank project trying to reform policing and judging. There was, I think, $60 million World Bank project in Bangladesh trying to reform the judiciary. In Sri Lanka, there was another big judiciary reform project through the World Bank. But because the judiciary is so independent, in India, it's been able to guard its independence in some ways even more than the government itself. When the government had to cave to all these reforms when it wasn't balancing its budget, the judiciary has always been resistance to people coming in from the outside. The only kind of example that I saw was the World Bank did this pilot project in Delhi for $500,000, just kind of assessing the Delhi judiciary. And I was reading through that report on kind of the assessment of that project, and at the end of the report, it's like, one of the things we did not appreciate enough is the independence of the Indian judiciary and getting buy-in from the judiciary locally, and you can't just get, you know, the Ministry of Justice to go along with this. So I think that, but this doesn't mean, obviously, that the Indian judiciary isn't influenced in many ways by transplants, outsiders. If you even, there's places like the Indian Judicial Academy, the national law schools, these centers where knowledge about the law is being developed within India. You see plenty of their graduates of the national law schools going out, coming back. You see somebody like Mohan Gopal, who was both the head of National Law School Bangalore, the head of the Indian Judicial Academy. He was also at the bank before that. So you see lots of movement of ideas across. And to me, it's never been kind of clear which way this is all going. And the transplant indigenous, although it's very politically resonant in India, this language and this rhetoric, I feel, at one level, it's unclear, you know, what's the insider idea, what's the outsider idea. And then I'm just going to end on this. I want to keep my remarks short, as I said, which is, you know, a lot of these things like the National Law School, the Judicial Academy, these were government interventions that they funded the National Law School, they funded the Judicial Academy, they funded the Indian Law Institute, the Indian Law Commission that's been coming out with reports since independence. It's been kind of a major source of reforms about law in India for some years. Increasingly, I think you see movement from funding from the government to the private sector, and I think that's worth noting, that you now see initiatives, not so much necessarily by foreign capital, sometimes by foreign capital, but by Indian domestic capital setting up law schools. So I was at the Jindal Global Law School for a while, which was set up by a steel magnate in India. Azim Premji University, which has a law and development, is probably going to be the first law and development master's degree in the country, he made its money in technology, right? And you see increasingly companies becoming more and more sophisticated at lobbying around regulations and rules around the securities, the SEBI, the Competition Commission, where you see both domestic and outside firms becoming active in shaping knowledge and that space. And I think that's worth noting. And you'll see, again, some more of this revolving door. So I think the current head of the Competition Commission was formerly at the World Bank, right? And so you'll see this resistance of the outside at one level, but then sometimes people are coming in through the back door. And it's a very interesting mapping of just how ideas are spread and the individuals who spread those ideas and how they are understood depending on what hat they have on, even though they're often the same people espousing similar ideas in each of those settings. So I'll just end there, but I want to say I very much enjoyed reading the paper.
Thank you.
Let me start by saying thank you to the organizers. Usually, when I get to go to law and development meetings, usually I'm there speaking about international law or Bretton Woods institutions or whatever. Usually my area of work is international law, but it was good to get an invitation to speak about India. Like Nick said, I also share Nick's view that it was Prabhakar Singh was given a tough job of pulling together a paper on something as vast and complex as law and development and trying to map it. And he's done a very commendable job trying to pull together various important elements and identified various key people who played a role in it. And I do think that this paper goes somewhere towards meeting the goals set by Dave Trubek to think about how law and development emerged as a study, you know, as a field of study, and if it did. I'm not yet sure that it has emerged as a field of study in India. As Nick was saying, it's not yet quite offered as a specialization in any law school yet, although it might change soon. Courses around law and development are very rare. Even Upendra Bakshi never taught a law and development course. He taught a course called Law and Poverty, which again tells you how people think about development. The word development was, seen in many different ways. But in a country with such vast, inequality and such enormous number of people who live in poverty, it was very hard for socially conscious people to teach anything about law without thinking about poverty. And so ultimately, progressives, whether they are sociologists of law, I'm thinking of somebody like Kalpana Kannabiran, who teaches in the South, or the first generation people, they all were people who came from the law and poverty angle. I do want to say that, India, like the other countries and the conversation that we have had so far, it's hard to say anything really concrete about law and development. India has many laws, many developments, and you can tell many narratives about it, depending on where you're coming from, what your entry point is. And I'm not sure that there is a New Delhi consensus either, if ever there was one. Often India is held up as an example of a country that has tried a rights-based approach to development. I'm not quite sure that that perspective is shared by even the economists, for example, that Nick was citing, or in the policy world more broadly. What India does have, of course, is a rights-conscious judiciary, but that sits often uncomfortably on top of a neoliberal economic order that actually, underpins, or that in turn sits on an unjust social order, which is governed by entirely different systems of rules and regulations, which are social, informal, and so on and so forth, not formally governed by law in a formal law sense. So what can I say that could add to this paper that would be useful? Well, I suppose, the longer perspective about what law is and its relationship to India as a country is a very large story. It's a very old story, because India, for a variety of reasons, as Prabhakar's paper says, became the field experiment for British colonialists to sort of experiment in using law as a tool of social engineering, and often aligned with the interests of local, social reformers, such as Raja Rammohn Roy that he quotes. But the other part of the India story is also interesting, which is that India was also the kind of the place where the British colonial engine basically tested how things work before they were tried on other countries. And that applied to law as well. For example, often, say, the Indian Evidence Act became a model for evidence acts in many African countries. In Kenya, until they changed the Evidence Act a few years ago, it was still called the Kenya Evidence Act India, so it was a direct import of the colonial footprint, was just incredible. There was that kind of diffusion and propagation of laws during the colonial phase, something that Duncan Kennedy, for example, talks about in his 3 globalization thesis in his piece. So I do think that the 3 maybe major dynamics that have governed in the immediate pre-colonial and post-colonial experience in the context of India when it comes to law and its relationship to the state, because ultimately when we talk about law, we have to talk about the state, and this project called development. The first major theme, I would say, is about the whole project of state making and state consolidation. And this assumed a particularly unique form in the context of India, but which then became the prototype for a variety of state building, state making experiments around the world, especially in Africa. And that involved basically the elimination of plural legal orders and the consolidation of land that is occupied by different communities and essentially who have de facto property rights over those lands, overnight declared as encroachers, sitting on their own land. Particularly, the early Forest Act adopted under the British colonial regime declared all the forest-dwelling people essentially as encroachers. And overnight, that land became state property. There was no state property as such until then. But there was common property that is distinctive. But the state eliminated any other competing plural legal orders. And that was part of the project of state building and state consolidation, something that we know that has happened, but through the work of scholars like Aidan Wiley or even the work of James Scott, who accurately describes how state making involved basically the elimination of indigenous communities and plural legal orders. And the history of indigenous communities in his most recent book in Southeast Asia has been about how do you escape state-based legal orders. And there are a number of people who have tried to do that. So part of the continuing battle in India, for example, over the Forest Rights Act, which returned some of the lost sovereignty to the forest people in recent years, is basically about this story. It's a story of competing sovereignties, to borrow the title from Mark Galanter, who wrote this brilliant book, Competing Equalities. So India's story in that sense about state-making consolidation, it's about competing sovereignties and going through a phase where it involved an erasure of private law, particularly erasure of property rights in land. And also, I would say that as a deliberately conscious choice, the decision not to develop any other areas of private law, particularly any legal regime governing torts. And that today remains a continuing issue. And the most egregious example where the failure of any tort law framework resulted in lack of accountability, of course, is the Bhopal case. And this has been well documented. And I don't want to go into the details, but if people are interested, we can talk about it during question time. So to me, this is connected to the broader issue of economic and social rights and the judicialization of ESC rights that Prabhakar mentioned. The basic question is, can the judiciary's more activist stance on ESC rights return economic and social rights, return some of the lost capacities of indigenous people and others through the erasure of private law? And here I'm a little bit less optimistic or sanguine about the story of ESC rights and Chapter 3 of the Indian Constitution compared to Prabhakar. I'm not quite sure that we can make the case that the Indian government actually put in ESC rights in Chapter 3 with the intention of guaranteeing socioeconomic rights. In fact, the very object of putting it in Chapter 3 and making them non-enforceable was not treat them as rights. And if anything, India's behavior at the international level totally showed how India had zero commitment to ESC rights. The resolution that was moved at the UN Commission on Human Rights in 1952, that became later on the resolution at the ECOSOC that led to the split of the covenants between the Civil and Political Rights Covenant and the Economic and Social Rights Covenant, was moved by India. India was the only major developing country to vote with the United States and UK in actually agreeing that, by the way, there is no need to actually have a set of enforceable economic, social, and cultural rights. A view that was not shared by many of the other developing countries, by the way. There was a split in the early 1950s. So I think we have to sort of problematize the early historical narrative of India's being a pioneer in economic and social rights. The second point I want to make is a large theme about law and the emergence of development as a project in India. I think it has to do with the whole struggle over equality. Here, it's very similar to the story that Dennis Davis was describing, 300 years of racist history in South Africa, followed by 50 years of apartheid, and then the post-apartheid struggle to sort of make equality mean something in reality. Now, the story of India is very similar. The story of the caste system and the struggle in the case of India led by Dr. Ambedkar, who was actually a Dalit, who was actually the chair of the drafting committee of the Constitution, to put the issues of bringing about material and substantive equality into the Constitution, without whose effort and without the advocacy of similar position by others, Indian Constitution would not have entrenched equality in the same way. Now that's a story I think I think it'll be good to sort of make it front and center to the story about law and development in the Indian context. In the case of that story, I think we cannot, of course, forget Galanter's brilliant book, Competing Equalities, which for the first time in many ways consolidated the findings and state of knowledge about compensatory discrimination or affirmative action in the 1980s, inspiring generations of law students, including, my first law review article, major article, was on comparative affirmative action in India and the United States, and Mark's book was the one that I was relying on. It's interesting because on the caste issue, if we look at, for example, something like the debate over Hindu personal law in the 1950s that Prabhakar, you were referring to, the interesting thing is that while Nehru stood for the reform of Hindu private law and he faced resistance from the president, in fact, Nehru might have been more to the progressive side of things compared to the president.
Yes.
But Ambedkar was farther to the side, the progressive side of Nehru, and in his view, the Hindu reform bill didn't go far enough. And as you know, they had a major split over that issue, and that led to Ambedkar's resignation from the cabinet. He never re-entered public life. I think it's very important to sort of problematize the kind of shallow liberalism that prevailed in the Indian context and the role of Nehru. The third issue that I want to briefly mention is, as a dominant theme, is the role of the judiciary. It was, of course, not always the case that judiciary played the enormously influential role that has been very accurately depicted in the paper, and Nick has also noted that. The interesting thing is not the judiciary is active, but the interesting thing is to ask, when is the judiciary not active? It's not consistently always active. It's active on certain things and not active on other things. And I want to propose that there are limits to the capacity of judiciary, or shall we put it this way, the capacity of rule of law to prevail over partisan interests. And that limit has essentially historically been supplied by something that I would call as the prevailing developmental ideology of the state. Judiciary ultimately is not free from the ideology of the state. It is part of the state, and it shares the ideological bias of the ruling class, and especially when there is a very strong politically articulated vision of development. For example, during the first phase of Indian growth in the 1950s and 60s, you could say that that was based on anti-colonial nationalism on the one hand, with commitment to industrial, development, and on the other, the court essentially shared that view, except for a few moments of conflict that arose over the property provision. But when the state's ideology changed to neoliberal economics and to urbanization, particularly the idea of world-class cities and so on, the court's ideology has suitably shifted, and we see the evidence of the court going along with the government's developmental ideology at various key moments. And I'll just give two examples. In the case of urban conflicts over land, for example, that involve the removal of squatters. There was a famous Almitra Patel case in which anyone who actually lives on any informal settlements was referred to as pickpockets. The judge was comparing them to pickpockets, essentially. In the context of rural, a large number of rural people who are affected by development projects, I would again give the example of the Narmada case, where the judges who actually pronounced the verdict in the case declared that it was in the interest of the people who are displaced that they should be displaced. It's good for them, essentially, and went into a very long rationale about how development needs to be brought to these people who are behind in terms of civilization and so on and so forth. The kind of discourse that you would think existed in the 19th century on colonialists, but it's astonishing how the developmental ideology of the state in turn can change judges who are actually quite aggressive and very progressive and activist on a range of other cases into following the prevailing ideology of the state. So I do want to suggest that the question of development ideology needs to be put on the agenda and seen in terms of what role law is capable of performing. It could, in other words, there's a slightly darker story about the judiciary than what might have come across so far. So let me just leave it at there and we'll discuss.
Let me begin by thanking the organizers for inviting me to this, what has been a very interesting day today and promises to be interesting tomorrow. I'll try and make 3 brief points, and let me first flag them and then try and illustrate them. So one of the disadvantages of coming last as a commentator is my fellow commentators have already covered much of what I have to say, but I hope that the examples that I'll use will sort of make the same points in a different way. So my 3 points are about terminology, about colonialism, and about constitutionalism. And let me try and sort of elaborate on that. So like my fellow commentators, I want to begin, and so the paper is actually co-authored. So there's Subrajyoti Gupta and Prabhakar who wrote this paper, and so the comments that I prepared were on the written text, which we all have access to. But I found Prabhakar's presentation interesting and the sort of modifications he's made to that, and I'll try and engage with that. So I think, again, if I was asked to do something like this, I doubt if I could have pulled together so many different strands. And I think this is a very commendable job of putting together a lot of scholarship and also sort of telling a story about post-colonial India. But on terminology, so we talked in the morning today about who qualifies as a law and development scholar. So I'm in the happy position of having actually published something in a volume that came out 3 years ago. It's called Law and Development in Asia. John Onosog also has a chapter there, and Professor Trubek, sort of, on his proselytizing mission was in Fukuoka in Japan, and a group of us got together and we talked about what does law and development in Asia mean. So the volume was published by Routledge Asia, and it has a paperback edition now, so which probably means that it's selling some copies. But what's interesting is, as I was thinking of Prabhakar's paper, I'm not sure how many of the people you've cited in the footnotes would self-identify as law and development scholars. And that's, I think that's a point being made by other people as well. So in terms of, we are here to mark 40 years of scholars in self-estrangement. Others have referred to Professor Galanter's work. And I was very struck by the fact that Professor Galanter first is not present here to mark 40 years. And I don't know how he identifies his own scholarship now in his very long and productive time as a scholar. So I think it's interesting that when he published his anthology of works now a quarter century ago, so it came out in 1989, and it's titled Law and Society in Modern India. And I think it's worth mentioning that Professor Galanter is very much involved with the Law and Society Association. He convenes the group on South Asia, I think, and British colonialism. So it's interesting that he sees himself as a law and society sort of scholar. So I guess the point that I'm making is not to say that we shouldn't include these people. I think there's a lot of scholars whose work probably qualifies as being part of the concerns of law and development scholarship, as we try to identify this morning what are the various strands. So Kevin Davis's point that maybe we should look at development much more expansively, and which would entail looking at issues of law and order, multiculturalism and pluralism, which as we've seen in India, of course, are hugely significant and have dominated conceptions of what is law and development scholarship. So in that vein, what is interesting now is if we are looking for people who can be part of this club of law and development, I would suggest that there are many scholars out there. And what is interesting, particularly for Indian studies, and Indian legal scholarship is now witnessing some kind of a revival, but in India, scholarship on the social sciences has always been first-rate and probably much superior to scholarship in other disciplines. So it's interesting that even as legal scholars are not focusing on issues of history which are significant, a lot of social scientists are doing that. So I'll give two examples and to sort of illustrate that claim. So Prabhakar mentioned personal laws, and of course the personal law regime in India has a lot to do with the health of its democracy. And in that sense, if it causes communal violence, you'd say, how is that an economic issue? Well, to the extent that communal violence causes loss of lives, loss of property, makes investors lose confidence in that, there is a concern, right? So when our current Prime Minister came to office, one of the big debates within India is, how is this going to affect India's image outside and his own sort of background? What are the consequences that it will have for the economy? So in that context, so it's interesting that for us Indians, it's a matter of no debate at all that personal laws are very much integral to a discussion of law and development. So in 2014, a political scientist named Narendra Subramaniam has published a book called Nation and Family, which really looks at personal laws in India. And it's interesting that he frames it comparatively. So in the previous panel, Jed was sort of saying law and development is anti-comparative law. But I think law and development in India has always been very comparative. And so Subramaniam's piece looks at, a book, I should say, looks at personal laws in India comparatively, looking at other personal law regimes and following what Balakrishnan was talking about, given that Indian personal laws were part of those colonial transplants to many different parts of the world, including Southeast Asia, Africa. The comparative study sort of looks at that and is a fascinating work because it's by a political scientist who's willing to move beyond legal doctrine. He actually does field work and interviews many people to also give you a sense of contemporary India and what is the state of personal laws. Moving on to my second, so that's the point about terminology, and I suspect we will be discussing this tomorrow in terms of how how do we get more people to be involved in that sort of broad phase. So the second point is about colonialism. So I think Prabhakar mentioned that, but in the paper, I guess you start looking at post-colonial India. And I think there's increasingly a sense of realization that given the long tenure, so just in South Africa, you spoke about 300 years. In India, too, you could speak up to 300 years if you start looking at the East India Company, followed by British colonial rule. And there's this group of scholars now, again, most of them are not legal scholars, but they're focusing on the colonial legal regime to try and understand what's happening in post-colonial India. So there's this idea of colonial continuities. Anil Kalhan has talked about that in the context of emergency powers. There's Arudra Bura has talked about free speech regulation and how the colonial period casts a long shadow on post-colonial developments. But what's interesting, and this is a work by a historian who's based at the University of Toronto, Ritu Birla. Her book, 2009, called Stages of Capital, is a fascinating work. So in a sense, Prabhakar points out in his paper how the traditional view of looking at the colonial economy in the nationalist terms is that it was exploitative. And that's what it was about. It was taken from, to use Mike Dowdle's language, from the periphery to the core, and that's what it was about. So Ritu Birla's work is interesting because she sort of steps out of that rhetoric of this was exploitative to say what was actually going on. And so she studies, completely legal instruments. So she looks at and things which I think Indian law schools don't do a very good job of talking about in great detail. So as a historian, she looks at the Indian Companies Act, and so she looks at legislation between 1890 to 1920, which was a very important phase because there's a lot of colonial legislation coming in. There's a Companies Act, there's a Trusts Act, there's a whole range of legislation which is coming. And her analysis sort of shows that what the colonial economy was trying to do was create a market economy, but it also came with very clear distinctions about what is public and what is private. And part of it was also trying to control indigenous commercial practices in groups like the Marwadis. And so her account is interesting because it steps away from the typical way in which we know it was exploitative, what's the point of studying it? And her point is to say it is deeply important to study that because later developments, and of course law being a very backward-looking self-referential practice, looks at previous models. And her book makes this very interesting sort of analysis of the Companies Act and Trusts Act and sort of looks at that till the 1920s. And what's interesting is since then, in other places, so again, not a law and development conference, but the South Asia conference at Madison has a panel where they're looking at colonial law, and this South Asia conference, again, very few lawyers are present. A lot of these historians and social scientists are studying the colonial economy to understand what was going on and what was the sort of... So in my reading of this chapter, those people's work very much qualifies as illuminating how do we understand what's happening in the post-colonial sort of framework. Because there is a tendency to say, India's wonderful constitution, 1950, what's happening? But if you don't understand what that constitution was grappling with, then it will seem like a failure, right? So the failed developmental state, for instance. So Meredith Wu and Cummings have this book, and people who study the developmental state are aware of that. But the one chapter on India is by an American talking about the failed developmental state in India. So why does that developmental state fail? I think colonialism is an important part of it, and trying to understand it dispassionately without looking at it through the nationalist bias will probably help us understand the state of the economy and why it was such a difficult thing to sort of control it later. And my final point, and I'll try and address something else that Professor Trubek questioned in the morning today about where is the South-South learning. So the final point is about constitutionalism. And so in one way, if you think about, and I think Prabhakar draws a good contrast between China and India, and you mentioned the 3-year. So the Indian constitution-making exercise is actually a fascinating exercise. If you think about it, these are people gathered in 1947. This is a subcontinent torn by partition. All kinds of violence is happening, but these people, while running the new post-colonial country, spent 3 years drafting this constitution. And the debates that they have are very much debates that are central to law and development. They're about how should we tackle economic development, how should we deal with democracy and human rights. So Uday Mehta, who's a political scientist, has studied the Indian constitution, and he says the 3 issues which dominated the imagination and the time of the framers of the Indian constitution over that 3-year period were first, how do you create this idea of an Indian national identity? Secondly, how do you deal with, and as Balakrishnan said, how do you deal with these vast inequalities, this extremely regressive legacy of casteism, of sexism, and various other forms? And thirdly, how does India regain its proper and justifiable place on the world stage? And Mehta's analysis is sort of interesting to make us understand what that project was about. So, at least for if you look at constitutional scholarship, and I think my fellow commentators have also spoken about that, much of Indian constitutional scholarship is really completely engaged with law and development issues. So at least for India, when you talk about law and development scholarship, you also have to cover constitutional scholarship. And I'll end with the last point about work that's been done. So there's last year I was part of a very interesting comparative project on transformative constitutionalism. This was a 3-year project, I think, which came to fruition in December. If you Google it and you say transformative constitutionalism in Pretoria, you'll get access to the book in its full form. The 3 editors of the book are interesting. They're Oscar Vieira, the Dean of FGV, Upendra Bakshi, and I think there's a South African scholar, Frans Wiljoen. And that's a fascinating example of South to South. And it's interesting that if you look at the structure of the book, it has some 30 chapters. Because first, you have to educate people about other traditions. So the first chapter is about what is Brazilian Constitution 101 for the South Africans and the Indians. And then they sort of, and the book is a massive project. I think it was logistically, and I think Adrian talked about the challenges of funding projects like that. How do you get that done? Location, and just as we've all witnessed, how many of us are grappling with jet lag at various stages? How do you get people together and get them to have a conversation? But it also reminds me, and going back to Prabhakar's point about BRICS, so transformative constitutionalism is obviously viable only for Brazil, India, and South Africa. In Russia and China today, in China you can't even mention constitutionalism apparently in scholarship anymore. So the idea of transformative constitutionalism is obviously not going to work very well. So I think, again, going back to this point of contextualization, I think depending on which country you're looking at and its history, if you want to take law and development scholarship, you will be looking in perhaps different places. So my point would be, so for India, studies of its colonial period are hugely important, and studies of its constitution and how the constitution plays out are very important. That, as we've seen very clearly in China, that's not seen as a priority. Their colonial experience was arguably not there or there in a shadow form, and that might be different. So perhaps that's one more thing to take away as we contrast these jurisdictions and try and understand what counts for law and development scholarship in those areas. I'll stop here. Thank you.
So many thanks, Prabhakar, for your presentation. Also, thank you, Nick, Raj, and Arun for your comments. We do have some time for questions now. We could collect some and then come back to our panel. Yes? Okay. So we have 1, 2. First. Okay. I saw three people asking.
Oh, no, visitors first.
Yeah? Okay.
Guests.
Okay.
Mine's a narrow question.
Okay, come on.
So this was actually tremendously enlightening for me, so thanks to the entire panel. Just a very narrow question, actually, for Prabhakar. Near the end of the paper, you say that you haven't said much about gender and critical theories, or they've been left out at one point, because they're not amenable to evidence-based analysis. And I didn't understand that, so I was just wondering, but I assumed you had something in mind there, because on the gender front, I was thinking of like Bina Agarwal's work, and so I suspect there's more to the story than that. So that was the question.
Well, I think the paper needs better editing, I guess. I mean, the thing is, the first problem was to basically map all of this, and as it has been said by other people, that we sort of have to first discover what law and development is and contextualize, and then sort of fit it within India. And I think, well, I need to be even more inclusive. This is not enough. So I guess, yeah, I mean. No.
Okay, so this is in many ways also a selfish question. So actually, when we were having this discussion, I actually was on a panel discussing the Transformative Constitutionalism book at FGV sometime last year. And it brought up this idea, right, that there's a lot of comparative work to be done on how the judiciary acts out social and economic rights as a development policy. And one of the issues that's come up in the Brazilian context is this idea of where and who are they listening to when you're producing empirical information about the consequences of certain types of legal action, right? So that inherently, right, has a developmental aspect to it. So I was wondering, and this is one of these things I'm thinking about, how do you map the influence of these things? It's like mapping technology, right? You drop sort of like a buoy someplace and you see sort of where it goes. And so I've been doing some work on labor rights and international discourse. And so India is often represented, right, in the international discourse as the representative of this neoclassical point that if you have too much labor protection, right, then people invariably get excluded from the market, and overall, right, there's a general decline, right? This is part of like the World Bank flexibilization like discourse. Okay? And then so I start reading things about the new administration coming in and sort of buying into this particular discourse, right, that labor law is a central area for Indian development, right? And it gets deployed in all these areas. I mean, I've read World Bankish reports that make really large empirical claims about what the consequences of fixing, right, Indian labor law is. So in that particular area, right, and you've mentioned some of the people who have the sort of transnational aspects of influence over particular ideology, but if there's like an idea like that and a court is having to evaluate, right, what is the actual consequence of labor law, right, in these particular issues that are raised, who are they going to listen to and where are they going to get information from, right, to make those types of empirical conclusions in like just that as a narrow field? I mean, you may not know about labor, but how does this implicate, right, the production of knowledge about the empirical effects of a particular type of law for this type of developmental regime?
We have more 3 questions. May we continue with the questions? Okay, it's the lady in red just behind you. And then
Thank you. I'm a student at the FGV, And okay, I'm going to make a question about India. Some times ago, I read an article about a professor from Berkeley. She was asking, she's Ananya Roy, and she was asking why India cannot plan its series. You know, it was the title of the article. And she proposed in that article that while in general, informality is often seen as a synonymous of poverty, in India, the absence of regulation and the ambiguity of law and the idea of exception are favorable at economic development, you know, that they are need if you want economic development, you know. And I think this is a provocative idea about how laws works. And she said that this idea is linked with territorial governance and justice. And she said that when you don't have regulation, you have absence of regulation, you have an idea of absence of governance, you know, and justice in the territory. And that's my idea, and I wanted to know your opinion about that. Thank you.
I want to just agree entirely with your point that one needs to broaden the debate. And in fact, you know, just thinking about my own country, which is South Africa, of course, there's a lot of stuff, as you rightly point out, which has to do with law and development without calling itself such. So let's just take two issues. Take this question of transformative constitutionalism. I think it's very wrong to look at that in terms of social and economic rights as on its own. Transformative constitutionalism is not about socio-economic rights. It's really about the question of whether you can actually reconfigure the ground rules of all forms of law. And particularly, that's why, Raj, your point about the dichotomy between private law and certain aspects of, if I could call it socio-economic rights, traditional or not such traditional constitutional law, is absolutely so fascinating. Because the experience then of India is very similar to the experience of South Africa, which is that when it comes to socio-economic rights, courts don't do a bad job. When it comes to questions of private law, contract and property law, then they scratch around, and there's a seriously kind of almost a schizoid approach to that as compared to the SERs. And so it's really interesting to drill down and ask oneself what is going on there. Of course, certain occasions, the courts don't actually do a bad job. So the issue about labor law, frankly, it's not so much about the courts, it's about the legislature actually coming under huge pressure to have flexible markets, which then, and that raises another interesting question, is to the relationship between what courts can deliver, how much heavy lifting, and of course, the Indian paper raises very profoundly, how much heavy lifting, political lifting can courts do? Or to what extent do the courts then go the way of Hungary, which is a very, very interesting case study for this particular relationship between, if you call it the economy and the constitutional jurisprudence. So what I'm saying is I'd be very interested in what your explanation is for that particular schizoid attitude. I know what we have for South Africa. And then, secondly, it seems to me you're utterly right. Your point is absolutely very valid, that if you look at transformative constitutionalism as a whole, there's a huge amount of play there to talk about the broader questions of law and development. And just to take one illustration, the Novartis case, which is the one I think you mentioned, the 2013 case, is a most fascinating example of how a court can destabilize a particular form of intellectual property, which has extraordinary consequences for development, not just only in India, as you rightly say. And that's another point, I think, where one needs to do a hell of a lot more work than we're doing at present.
Would you like to react? We have more questions.
Okay, I'll be very quick. I think it's too bad if China and the Chinese constitutional order weren't included in that discussion, because it's a constitution, it's just a Soviet constitution. And what could be more transformative than a constitution that vests all the authority in the executive branch? I mean, if you want to, you're back to the developmental state. I mean, that's part of the developmental state thing, is to have an executive branch that really isn't answerable to anybody else. And that's what the Chinese Constitution does. And one thing that I think is unfortunate is that people don't study Soviet law anymore, right? The Soviet law as a field is just gone. So people look at China knowing nothing about Soviet law, and they think, oh, there's all this weird stuff going on in China. And because the Constitution doesn't do what we think constitutions should do, a separation of powers and courts that can litigate the rights and adjudicate the rights, then they don't have a constitution, and we shouldn't think about it. I'm not a fan of the Chinese Constitution, but if you want to understand how things work in China, the Constitution does matter. And strangely, the current regime, they've had a slogan of ruling the country through law for a while, and people have a big discussion about, well, does that mean the rule of law or rule by law, blah, blah, blah. Well, the new slogan is ruling the country through the Constitution. So what does that mean? I mean, if you're not paying attention to the Chinese Constitution, you're not going to pay attention to that debate, and that debate clearly means something. I don't know. I'll defer to Professor Wang about what exactly it means that they're now talking about ruling the country through the Constitution, but it means something in the Chinese context.
We have one last question. Yes, and then maybe we could have your reactions. Maybe.
So I very much enjoyed the panel as well, and this is a question about the sociology of knowledge and the influence of ideas. I was struck by the reference to so many Indian scholars, particularly in development, Bhagwati and Sen. And so since we're going to talk about South-South and South-North relations too, I wonder whether you see there as an important connection for people, for Indian scholars and intellectuals who are interested in making an impact back in India, to have to do that from either the UK or the US, that is from the West. And a very, I think, obvious and interesting precedent to that would be Gandhi as well, right? So the trajectory of Gandhi, which actually in some sense connects the history of India and South Africa. Him, a lawyer in South Africa, fighting against discrimination. And so I'm just curious to know your ideas about how this process works in terms of the Indian diaspora, and whether there are any lessons to be gained from that phenomenon.
Okay, I think we could start your reaction. Yeah?
First
Can we start
question.
with Prado? Go, yes.
The first question was about labor laws, right? And so your question was as to how to retrieve empirical data on labor law, right? That was your question.
Who produces it and who listens to, interrogates it when it comes to policy making in the judiciary or otherwise?
Well, to be honest, I think it's a difficult question for me to answer, because unless you are a practicing lawyer, I mean, in particular field, you wouldn't know this. But I will try to take an educated guess. So I think much of the decisions that the court makes is, there's a phenomenon of, I think, amicus curiae, through which there are organizations, for example, in the Novartis case that I discussed, for example, the WHO and another NGO, which was very concerned about the outcome of the judgment, because it sort of, made extensive presentations, and the court in the judgment mentions that, because the head of the WHO, and they have said this, and this is their view, and they are right in their view. So the court, of course, on its own cannot generate empirical data. It just cannot. The executive, unless it is mandated to do that, it won't generate data. But because of this, the window that it allows to let informed citizens and NGOs come in and tell you what it means, I think much of these internationalist judgments, enlightened judgments, are informed by these, Indians and international, NGOs and information banks, in a kind of information bank. I don't know if I answered your question, but yeah, just drawing on.
Yeah. Do you want to comment on questions?
Sure, I'll just make a couple quick comments. One that I know a little bit more about. So on the ideology of the court, I think it makes a lot of sense. I've spent some time looking at the Supreme Court and with a number of judges, and I the point about the Indian Supreme Court at a couple of levels is it's a very fluid court. in the sense of there's a lot of judges, there's a lot of benches, it's a polyvocal court, it's speaking with many different voices at any given time. That includes on development issues. That said, it's also a middle-class court, I think, is the way I try to characterize it, not in the sense that it's always looking out for the middle class, but it's middle-class individuals with a certain view about what development means. You can have different people on that spectrum of the middle class of what they think development means and how to best effectuate development. But I would say that. And I also say on the social and economic rights on the public interest litigation, there's no empirical evidence that any of this leads to development, right? But as this is a methodology question, which is, and I've thought about this a little bit, it's very hard to figure out how you would ever show this one way or the other. But it certainly is part of where the court gets its legitimacy. It's a part of the idea of the judiciary. They're in the papers all the time. One of my favorite statistics about India is if you Google Supreme Court, you Google Parliament, and you Google Prime Minister in the Times of India, you'll have far more articles about the Supreme Court, as many articles about the Supreme Court as Parliament and the Prime Minister combined. There's very few countries you can say this. So it's in the popular imagination as well, at least the middle-class popular imagination. But we don't know this relationship, and this is true in rights rhetoric in general. So, Devesh Kapoor, who's at UPenn, I don't know if he often says this about some of the, Amartya Sen and other people who've taken over kind of some of the international development rhetoric. He says, well, this is great, but if you look at who has really pushed forward in terms of economic development, look at the Asian tigers, look at China, look at South Korea. They didn't do anything that Amartya Sen told you to do. And so there's this debate even within kind of the Indian space as well about this. But
Okay. Briefly, on the labor law, my first job out of law school in India was to become a lawyer in a labor law firm that represented unions. And my sense about this, my dad's a labor lawyer, and I now my knowledge about labor law is purely theoretical, that comes from random conversations I have with my dad, and of course, reading stuff about labor law developments in the paper. I don't do anything, but my sense is that what really happens in labor law is really not court-centric at all. It's really all about labor inspectors. The actual implementation of labor law is where labor law is. And that's at the level of labor inspectors who have very long and fairly dependent relationship with particular industrial enterprises that they're paid to not to inspect, essentially, over a period of time. And these are very reliable measures. So the bribes can go anywhere from just a bottle of whiskey to a TV, to a cash, or whatever. But that's a political economy of corruption, basically, that defines the role of the state. The judiciary is, in terms of the judiciary's role in labor law, it's probably still the case that all the old judgments, progressive pro-labor judgments by the Supreme Court, still stand. They have not been overruled by any of the current benches yet. Although with the onslaught of the labor law reform project from the outside, some judges might jump onto that. On the question about Ananya Roy and her piece, it's actually a good piece. I do think that it's the case that there is an idea of exception. That's how Indian cities are planned or not planned. But I think, in some ways, she doesn't follow her own conclusion that, if it is by exception, then the system is not, so the ways Indian cities are is not a failure of the system. It's, in fact, a success of the system. Because the system is designed to cause all of those problems. Because some people are benefiting from it. And I do think that was an issue on which she has been, in fact, critiqued many times, that she doesn't quite, because, as you know, in that piece, she doesn't go to talk about, okay, we understand that it's an exception-based rule, but what do you do about it? The other thing that she doesn't quite get to, and that's because she's not a lawyer, is the nuts and bolts of how do you actually create an exceptions-based regime. And that's been done a lot by constitutional scholars. For example, they've looked at how the Delhi High Court constantly uses, non-speaking orders, simply that won't give any justification. And these orders are in the hundreds, and they are used repeatedly for coming up with decisions that evict the squatters, that uphold environmental rights, quote unquote, as a way to sort of clear particular parts of the city so that they become beautiful and so on. And that actually is the mechanics of how things work. And again, all this is by choice, right? The system is designed to fail that way. The same way why tort law never developed is because it's the choice. Why are, the ad valorem fees so high in India for filing a tort case? Well, it's by design. It can be changed, right? The third issue, Dennis, about the ESC rights and private law, how much heavy lifting can the courts do? I have no idea, but the Indian courts have pushed the boundary more than any other courts have, and more than most Indians thought possible. They've had judgments, I think Prabhakar refers to some of these judgments, where they openly critiqued, for example, the Jharkhand government, or was that case for their neoliberal economic policy, and they've stepped into hugely controversial issues like allocation of 2G spectrum, licenses. They've canceled all kinds of, big decisions by the government. But having said that, I think that the court, while it is highly popular, as Nick says, it's probably also suffered the danger of becoming another organ of governance, because this is something that I tried to sort of articulate in a paper some years ago, that the judiciary in India is no longer simply about dispute resolution or even provision of justice. Not about that, it's about governance. And it's because judiciary has become an organ of governance that, in fact, it's a good thing and a bad thing. Because the good thing about judiciary serving as a function of governance is that, well, the other institutions are failing and you need somebody to make the decision, and that's the reason why the courts are very popular. But the bad thing is that the judiciary is put in the position of having to sort of share the biases that are implicit in governance. Because any governance project is based on the ideology of the state, ultimately. And that goes back to my earlier point about we should be careful not to overlook the ideology part. The last part about sociology of knowledge, I have no idea why it's turned out the way it has, the inside-outside flow of ideas. But it is actually, in terms of at least economists, it never used to be like this always. If you look at Mahalanobis, who was actually the economist who put together all the 5-year plans, he wasn't actually trained abroad. He was actually a statistician who was trained in India. And he had a very close relationship with Nehru. And the number of economists in the formative years of the 50s and 60s had nothing to do with foreign institutions. But then comes the Delhi School of Economics, and then a wave of people who actually graduate from there, who then, after teaching there, they all migrate back, because they're all people like Amartya Sen who got PhDs from Cambridge, and they end up in Western countries, and then begins the revolving door of outside economists, and the ideological battles that pit a Bhagwati against Sen, and so on and so forth. And I do think that it's a newer phenomenon compared to, say, lawyers. I think lawyers have a much longer history of being trained outside, like, as you said, Mahatma Gandhi onwards, or even earlier, others who have actually been leading social reformers in the Indian context and been leaders.
Very quickly, so to Jed's point, I think, so Balakrishnan has a piece some years ago where he talks about the court since the 90s, the neoliberal court, and how the schizophrenia that he was describing. I think for labor law as well, I think the backsliding has already started. So there was, some years ago, a Supreme Court 2-judge bench ruling says there is no right to strike in India, and there's no fundamental right to strike.
For government employees.
Right. And so I guess labor lawyers are now thinking that is already imperiled. And the golden age, so in the 70s and 80s, the Supreme Court was completely behind labor unions, and it was seen as having gone too far on the other side. And now the corrective, apparently, is to restore the balance in some ways. But your question about empirical sort of knowledge and how does... So those who support what the court is doing will look at cases like the right to food case, right? And the governance code. So both Nick and Balakrishnan have written about the court as a governance agency. But what the court there is doing is really making up for the deficits of normal executive functioning. And what they would do is somebody brings a case to the court and says there's a government scheme which is supposed to provide food and it's not working. So the court calls the government officers before it And then they will often say, well, there are these bottlenecks in the system. Then the court appoints commissioners, many of whom are retired bureaucrats who know exactly where the gaps in the system are, and says, you go and investigate what's happening and come back to us. So they come back with lots of details. The judges obviously don't know how this works, but they rubber stamp whatever is told to them by the commissioners. And in cases which I think progressives think of as good cases, the right to food case being one, they say the court is not imposing its own ideas. Frankly, in most of these cases, it doesn't know what's going on the ground, because these are very complex decisions. And cases which progressive communities like are the ones where the court allowed other people to step up and give it information. And in those cases, the government is quite happy to go along with it, because trying to push that politically would be very difficult. But to say there's a Supreme Court order and we have to do this sometimes becomes convenient. And in that sense, it's not a classic judicial review thing. It's really an administrative agency which is trying to try and find out where things are going wrong, and they go on. But unfortunately, along with those good cases, you also have these other cases which are not progressive, where the judges impose their own values. And again, this is a space where comparative sort of experiences are very interesting. So I'm working on a piece right now where I'm struck by what the Supreme Court of India is doing in the right to food case, and what the Colombian court has done in the IDP case. And there's real parallels with how the court is being a very careful negotiator and watching what's happening and using people in government and using local politics to sort of drive the litigation forward. So I think in that sense, I'm a qualified defender of the court's work in these areas. And in a sense, what the court is trying to do is going exactly at the issue that you've identified. How do we know what's happening, right? You can't just rely on government reports or whatever conventional wisdom is there. And progressives are aligning and making very interesting allies in terms of who do they use to try and get these cases forward. Just one last thing on that. I think, so Nick's point about, I suspect things have changed over the last 3-4 months. So with Narendra Modi being, and so what is unusual about India is we're at a very interesting moment where I think for the first time in a quarter century, we have a single party dominant government, and it's a party which controls 333 seats out of 540. And so Modi has that, and I think the backlash has already started. The first constitutional amendment passed since this government comes in is on judicial appointments, and that is to cut back. So I don't think it'll end up in a Hungarian situation, because I think, frankly, most lawyers in India also think this is a completely unjustifiable situation, what the court is doing. But I think progressives are now worried about what this means in how the balance will be restored. So I think India is now in uncharted territory, and it'll be interesting to see what happens as we go forward. But that might well change on that front. So very quickly, John's point, and I'm sorry, I should have been clear. I'm not saying that in China constitutionalism is not relevant, right? But in that, I think I take your point, and all the Chinese exchange students I have who want to write about constitutionalism in China, surely that means something, and there is something about the rhetoric which I wouldn't want to ignore. But I guess my point was to say, in each of these, if you have to do this contextual way of even looking for middle generalizations, the subjects of our generalizations might be different in different societies, because the branches of law, the rhetoric might be different. And I think we need to recognize that going forward. Alvaro's point, again, I think a lot of that is because, unlike China, India has still not fixed its education system. That's why you have an extraordinary number of people outside. And maybe that's a common problem in the BRICS countries as well. Though China seems to have at least made a real effort to try to get academics back in terms of money, in terms of openness, not clear. But I think I'm going to take off on a slightly different point. And when we are talking about South-South cooperation, what is striking to people who are studying this, so there's a new book out by Ramchandra Guha, who's written a book about makers of modern India. And this is a book called Makers of Modern Asia. And he chooses 11 Asian figures, which will be quite controversial. 4 of them are Chinese, 3 of them are Indian. But what is interesting in the book is, and it's written with a very South-South idea. And what the people who contribute to the book focus on is how, in the post-colonial period, all of these people were very consciously looking at each other. They weren't just looking at the West. So Prabhakar's point that you have Americans coming in, and they were also looking. So for Nehru's interest in China goes to 1920s. When he's sort of talking and he wants to build links with what's happening in China and find partners. So for a while he thinks Chiang Kai-shek is going to be it. He's terribly impressed by him, and of course that doesn't work out. Then he builds bridges with Zhou Enlai and others. So what's interesting, I think, is it's not a new phenomenon. There have been these people who've been looking to other countries in similar situations to theirs earlier. But that hasn't been emphasized. And I think some recent scholarship is trying to look at that. And so next year is the anniversary of the Bandung conference, which was a fascinating site for people from Asia and Africa coming together and thinking about how do we grapple with these issues. We're dealing with nationalism, of democracy, of rights, and economic development. And how do we sort of build that? And I think that's another thing we should be looking at also, previous attempts by people trying to make those South-South linkages.
Okay. We have one very last question. Can we? Would you like to, Michele? Yeah? Okay, now we go. Thank you, Alvin. We have time, so one last. Because the discussion is interesting.
Well, maybe this is a question that we can discuss in the panels, not only today, maybe tomorrow, but when this is a question to Haj. My name is Michelle. I'm a professor here at FGV, and it seems familiar to me when you mention that India has many laws and many developments. This is like a feel when I'm writing about Brazil and describing, and when people ask me about Brazil. But what is different is the way that you mention your idea of a pre-colonial and a post-colonial society. This is not a type of memory that we have in Brazil. So then when we are talking about land development, it's easier for us to think as from the the colonial period, and it's easier to get an impression of progress in Brazilian debate. And I guess that is it prints a difference from the Indian debate, what I get. So I would like to hear from you, what do you think that adds this narrative of having a pre-colonial memory to your debate on law and law, and on development, and on law and development, if you think it makes a difference?
I think this is something that you also touched on, Arun. I do think that there is a difference in that sense. The memory, the pre-colonial memory, does serve a function in shaping the field and determines the kind of questions that you ask. And I do think that the pre-colonial phase or the experience or the memory is important, at least in two different ways. One is the pre-colonial memory is important politically, in the sense of the way in which it drives a new project, which is associated with the constitutional moment, such as, for example, South Africa's break, that moment of break with apartheid. Of course, it did mean that all the structures of injustice that came out of apartheid actually had been eliminated, but politically seeing that as a break then provides a new set of justifications for a new vocabulary, a new set of institutions, and possibly a new constitutional morality. And that constitutional morality is what was, I think, the biggest difference in the Indian context. Because if you look at the Indian Constitution carefully, in fact, it bears a lot of similarities to the 1935 Government of India Act, which was a colonial instrument. On the other hand, there were certainly distinctive and very important innovations that were made during the brilliant 3 years of drafting of the Constitution, but there are a lot of similarities to the older structure, and not much change. For instance, the biggest structure that didn't change was the bureaucracy. Nehru decided to keep the bureaucracy, and that was a controversial decision among many, especially retrospectively. But I do think that the break, the way in which you think about the break is very important. And because it provides justifications about how you think about reform. So the way South Africa thought about reform obviously determined the way in which they approached the constitution-making project, where on the one hand they had a long list of ESC rights in the Constitution, but on the other hand they had a right to property clause that in many ways, while very elaborate and detailed and full of guidelines, it protected the property interests of those who came from the apartheid period. Similarly, in the case of India, the property provision was put in there that generated 30 years of litigation before being subjected to withdrawal. But oddly enough, the withdrawal also coincided with a moment when the state had finished consolidating its control of India's land. So the question of whether your property rights mattered less than who is in control of the state and what the ideology of the state was. And if you look at economic growth rates, for example, India's best growth rates came after constitutional right to property was withdrawn from the constitution, not before, when it was supposed to have the so-called elephantine rate of growth. I do think that the break is one important part of the consequence of having a pre-colonial memory. The other way in which I think a pre-colonial memory is important is in terms of the sort of the path of dependence that comes out of the recent historical work that Arun Kumar was, Thiruvengadam was referring to. A lot of it is assumed in some way, but relatively poorly understood and documented. You know, for example, knowing a lot about the way in which Companies Act and Trust Act actually transformed gives us a sense of what forms, you know, of corporate ownership or corporate governance practices actually became part of the Indian, you know, social reality in the coming years. And I do think that having a pre-colonial and memory in that sense provides a better understanding of path dependence, whereas in the case of Brazil, because it's seen as one long continuous period, it's very hard to sort of say, here is where the break occurred. And let's think about what was from the past and what has continued to influence, despite our best attempts under the 1988 Constitution, with this idea of, you know, social function of property and so on. Somehow things haven't quite worked out the way, you know, they were expected to. So it is a big question, as I know, among the Brazilian lawyers and intellectuals. So I do think that at least in these two ways, you have a big impact when it comes to thinking about the pre-colonial memory.
Okay, let me thank our panelists for this very interesting discussion.